without any further ado, I'd like to introduce Don Ericson, our resident firearms instructor, who's going to talk about self-defense law and safety.
All right, I'm going to try to stand someplace where I will be not in the way. So that's me. Let's do firearms safety rules. Rule number 1 is?
Assume that the gun is loaded.
Always assume that the firearm is loaded, and I like to add perform a condition or safety check, and what that means is if I want my firearm unloaded, I need to make sure it's unloaded. If I want my firearm loaded, I need to make sure that it is. Sometimes people forget and they just assume it's loaded or unloaded, and that's when mistakes happen. So always check the condition of your firearm. What's rule number 2? Or another rule?
Don't point it at anything you're not planning to shoot.
Don't point it at anything you don't intend to shoot. That's not my rule number 2, so I'm going to pause. That's my rule number 3. What's rule number 2?
Your finger, not on the trigger.
Keep your finger off the trigger unless you have a P320. You shouldn't. The gun should not go off. All right.
Unless you drop it.
There are a few that, yeah, there's a few that if you drop them just right. And the last rule.
Check the background.
Check what's behind you already shooting.
Know your target, know what's around it, know what's behind it. Alright, we're going to watch a short video. I hope you can see it clear enough, but what I want you to look for, and feel free to call out any of the violations of these rules. This is occurring in a big box store like a Bass Pro Shop or this is neither one of them checked the gun. You got a store clerk that works in a firearms store and a law enforcement. What else? Fingers on the trigger. Pointed at it himself and at other people. But all that's okay because the gun's unloaded. Oh, maybe not. He will not be flipping anybody off with that hand. He shot his middle finger off.
You know, we ought to make a new rule for that.
What's that?
I don't know what it would be. But
Well,
it would be that.
the rule is always obey the firearm safety rules. Both of those gentlemen knew the rules. They didn't apply them. They made assumptions. It would seem logical that the firearm in a case at a gun store would be unloaded. That is something you should not assume. All right, the big part of what I wanted to talk about is I enjoy shooting in a number of different levels, but my primary interest is in self-defense, and knowing the law is really important in every state that you are carrying your firearm. I'll pause too to mention Barry had on the sheet here, the sheriff had put out a statement related to our permitless carry in Florida that went into effect last year. So if you have any questions about it, there's some information about it. But knowing the laws are critical. Why are they critical? Because if you are involved in a self-defense incident and you have to go to trial, you're going to be facing your peers, right? You can pretty much bet they're not your peers. The prosecution is going to make sure that there are no gun owners, no USCCA, no NRA, no concealed carry holders on your jury. So it won't be your peers. None of us will appear in the jury for any of us if we had to use our firearm for a deadly force. So you absolutely have to know these laws in order for you to have the best case should you have to defend yourself. We're going to look at just one segment of it, and that's going to be justified use of deadly force. There are 4 elements. Those 4 elements must always be in place in order for you to claim self-defense. Disclaimer, not a lawyer, educator. But we'll be looking at components, and even if you can't see this really well, no, you can't read that, can you? That's all right, I'll just illustrate, talk. The first element here has to do with being in immediate fear of death or great bodily harm. Now, laws have very specific definitions behind each of those words, and so the question is, what really constitutes being in immediate fear of death or great bodily harm? Masad Ayub, who's a well-known firearms instructor, decades behind him, an expert witness in cases like this, he's come up with what he calls the AOJ triad. So there's three things that have to come into play in order for you to have the defense of this first element, immediate fear of death or great bodily harm. The A stands for ability. The attacker must have the ability to inflict great bodily harm on you. O stands for opportunity. He must have the opportunity as well, and we'll illustrate this a little bit more in just a second. And the J stands for jeopardy, or he has to show some sort of intent that he wishes to harm you. So, just because you are afraid of something, that's not all. Sometimes people think, as long as I say I was afraid for my life, then I can kill anybody I want. Well, no, that's not quite right. So, knowing that and being able to process those things in split seconds are very critical. So, for example, this you can barely make out, but the gentleman in the upper left-hand corner has a knife. Does that person have the ability to harm you?
Yes.
Does he have the opportunity? And that may depend on how close, with a contact weapon, how close that individual is. You may be familiar with what's sometimes referred to as the Tueller drill. This was a sergeant with the Utah State Police, maybe, Dennis Tueller. He had raised this question of how close can a person with a knife get to an officer. So what they determined was how fast can an officer wearing an outside the duty rig holster, knowing that an attack is coming, how quickly can that officer get his handgun into play and put target shots downrange on the attacker. Figured about 1.5 seconds. So then they asked the question, how fast can an attacker generally run? And they can run about 20-something feet in 1.5 seconds. So how close do you want to let somebody get to you who has a knife and is threatening you? 21 feet would be the range for an officer who knows it's coming and has an outside of the duty rig on. So I would suggest, as a conceal and carrier, I'm not going to let them get 20. I'm not going to let them get 20 feet. That may be way too close, and I'll show something later. But you're going to have to figure out which is why it's important if you conceal and carry, how long does it take you to get your firearm into play? How quickly can I clear my garment, pick up my firearm, and put it into play? I would say probably, depending on the distance, most of us would struggle to do it in 1.5 seconds. That's fast.
Well, we do the run and gun, and we get timed on that.
Yep.
The steel challenge, rather. The fastest I go is like 2.25, something like that. That's my fastest time.
Yeah.
So, I don't know that anybody can do it faster than that. Maybe you can, but not me.
Again, depending on the distance and all of that, it's going to take you some effort to do that. I'm just encouraging you need to know how fast you get your firearm out, and then you need to gauge that. What's 21 feet?
7 yards.
How far is 7 yards?
21 feet.
From about, yeah. So that's the other thing is.
So how far are you to the door right now, do you think?
I am about 21 feet.
Okay.
Yeah, so that distance, if somebody's threatening me with a knife, set aside media and all of that. You need an expert witness who can explain that to jurors who do not understand this. But you might think, to shoot a guy that far away from me with a knife, that seems unjust. We'll show why it's not in just a minute. All right, these others you can barely make out, I recognize, but again, this upper corner here, you've got a gentleman with a bat trying to take this woman's purse. Does he have the ability? Yes. Opportunity? Jeopardy. Yes. Same here. This is a man pointing a firearm at this young lady. Here you can't make it out very well, but there's a man dragging a woman out of the car. He appears to be unarmed. Does he have the ability to cause her great bodily harm?
Yes.
Does he has the opportunity?
Yes.
Has he shown jeopardy?
Yes.
All right, so all of those have to be articulated in a court in order for you to meet just the first element of self-defense.
I got a question.
Yeah.
You remember that scene they had on the TV where the woman was getting smacked by a guy? She bumped his car, he come out and started punching her, and she shot him,
Okay.
killed him.
I don't remember that specific one, but do you think in what Ron's just described, can that woman articulate that the attacker, was it her boyfriend?
No,
Okay.
it was a stranger.
Stranger would make it even more. Does the person have the ability to, does he the
You can see
opportunity?
her head,
Yeah. So
he took a good shot at her jaw.
now, if it was two guys of equal height, equal age, getting into a fist fight, would that justify the use of deadly force? Why not? You'd have to be able to articulate why. I could share numerous different cases where sometimes people have been able to articulate, this is why there was a condition that person didn't know, my attacker didn't know, but I had a condition that his attacking me could have caused me my life. My heart could have stopped or whatever it might be.
Yeah, but that woman, they arrested her and took her, she's going to court for that.
You will likely be arrested, whether you're justified or not. The law enforcement officer, that's not, part of their investigation will determine that, but they're not the ones who primarily do that. Who primarily decides whether or not to press charges?
District attorney.
Yeah, district attorney's going to do that. If he has any questions or if he wants to try to cover himself legally, what does he do? He'll charge you, or he'll take it to a grand jury, which he, and only he or she, presents his or her case to the grand jury, and they decide whether they think there's enough evidence to convict or to charge the person. And so then they're being charged. But can you think of any instances that had national attention where people were arrested for defending themselves and went through lengthy trials, only to be found innocent? Rittenhouse is one of them. Daniel, yeah, so it's out there, and it happens a lot. All right, the second pillar is you must be innocent. You must be the innocent party. You cannot be seen as starting this event now or in the past. You have to be seen as the innocent party. Does anybody remember the Daniel Perry shooting?
New York?
Texas.
Oh, yeah, the guy on the porch.
No, that's a different story. So Daniel Perry was the guy who was an Uber driver. He was driving people downtown Dallas, I want to say. It was during the BML riots or peaceful protests.
Mostly peaceful.
Mostly peaceful. In this case, he was stopped in traffic. People were yelling, pounding on his vehicle. A gentleman with an AK came up to the side of his car. Daniel felt threatened. He pulled out his pistol, shot the man, killed him. Daniel Perry was arrested and convicted. Did his attacker have opportunity?
Yes.
Yeah.
Did he have the ability?
Yes.
Was he shown jeopardy?
Yes.
That was part of the argument. So that meets the first pillar. The second pillar, was Perry innocent in this case? Here's why he was convicted. He had a couple social media posts, one of which he was posted to a friend of his on Facebook. There were some protesters outside his apartment causing quite a disturbance, and he made a comment about having to shoot some protesters or whatever. Similarly, he made a post to another friend who there was protests in Dallas, and he said, I might have to go up and shoot me some protesters. That argument, you don't think about it at the time, you're just venting, but those can get you in trouble. So the prosecution said, hey, this dude's not innocent. He was looking for trouble. He drove downtown. He was looking to take somebody downtown and drop them off so that he could get in some sort of confrontation. Fortunately for him, the governor of Texas pardoned him, but that's why he was convicted. All right, next is, this has to do with proportionality. This has to do with no lesser force would be necessary to end the threat. So for example, in this first picture up here, you've got a woman whose purse is being stolen. The gentleman doesn't appear to be armed, so does he have the ability to cause her great bodily harm?
Yes.
Okay, does he have opportunity? Has he shown jeopardy?
Yeah. He's only grabbing the purse.
Yeah, I was going to say, here you get, he's grabbing a purse. That's what appears to be his intent. He doesn't appear to wish her any other harm than stealing her property. Can you use deadly force in Florida to protect your property?
No.
There's only one state that allows it.
Texas.
It's Texas. Texas, you could shoot somebody for peeing on your truck if it's at night. So, Texas. When I moved to Texas and started reading their laws, I'm like, holy smokes, it's crazy. Now this one here, I wish you could see this better, but there's a gentleman over here who has a knife. There's this big buff dude who pulled out a gun and shot in this scene, appears to shoot the guy. Would that be justified?
Sure.
Yeah.
He's got a knife. The other guy's big. He can handle himself. This is a little skinny punk.
It's irrelevant.
Still
It is irrelevant.
It's irrelevant.
The fact that he brought a knife to a gunfight is irrelevant. The fact that this guy's big and buff and the other one's not, all of it's irrelevant. Down here, again, deep apologies, last minute scrambles to put something together for you, but here you've got a gentleman walking towards this woman. He's carrying a tire iron. She is apparently concerned, and she's not flashing her belly button. She's reaching up and grabbing a handgun underneath her bra and presenting a firearm. Does that look justified?
Yes.
Because?
He's got it.
weapon in the house.
Go back to, does he have the ability?
Yeah.
Yes. Does he have the opportunity?
Yes.
Has he shown jeopardy?
Yes.
Maybe. He could be going to change a tire. I mean, if he's just walking and carrying a tire iron, the woman would have to be able to articulate, hey, he was making these rude comments, he was giving me the eye, he was whatever it might be. That's why I felt threatened. You're going to have to be able to present a reasonable case to a jury. Now, would the jury be more sympathetic to the woman or the guy with the tire iron? It depends. It really depends. You're rolling your dice on a lot of these things, so you have to be able to think through these things rather quickly.
If you were in the city of Seattle, it'd be more sympathetic to the guy with the tire iron.
Probably so. So that is an excellent point, because where you are makes a difference. Who the prosecutor is makes a difference. What we could start to say what we can get away with, but as what we can get away with here in Marion County, you're not going to get away with down in Orlando or Miami. It's a whole different environment. So you need to keep that in mind as well.
Isn't that last example an issue with disparity of force? Potentially?
It would be, there is a disparity of force difference there. You have a woman, actually she could probably make a good argument whether the guy had a tire iron or not. He's a young, strapping young man. He sees the woman, says, hey babe, how's it going? It's close enough. Oh, come on, honey. Hey, you need to stay back. Babe, this. Would that be enough for her to yeah, she could then draw her firearm. If I was walking down the alley and I was carrying a tire iron and a woman looked a little bit concerned, she said, hey, you need to stay back. If I said, oh, sorry, not threatening, just going to change my tire, and I walk away, I'm obviously showing the intent of not harming her. But if I keep advancing on her, she would be able to articulate, this guy was making me really uncomfortable. All right,
So once she displayed the weapon, she didn't need to use it.
well, in this scenario, you might assume the guy with the tire iron was smart enough to go, yeah, tire iron against a firearm. Anybody who I'm gonna say it anyways, I don't want to offend anybody, but any woman that carries a gun under her bra, I'm not messing with. That's that gal is prepared. All right. The last one has to do with no reasonable means to retreat. Now, there are 12 states, I could read them to you because I know that's on my list, except, yeah, you could probably guess New Jersey, New York, Washington, California, Massachusetts. Oregon's not on the list. This is a duty to retreat.
Rhode Island's on there.
Rhode Island, yeah.
New Jersey, Wisconsin, and the one that's, Hawaii, which doesn't surprise me. I don't know if anyone said Delaware or Connecticut, Maine. The one that kind of surprises me is Nebraska. But you need to know what state has a duty to retreat. We have in Florida what's called a soft, we have stand your ground, but it's what's called soft stand your ground. Now in states that have, some states that have a hard stand your ground law, the prosecutor cannot even bring up the matter of, hey, he could have retreated. Sure, we have stand your ground, and this was the case with,
Trayvon?
that's a different story which we will get to, with Rittenhouse. The prosecutor tried to argue he didn't have to shoot him, he could have retreated. Well, actually he was retreating, he was running for his life, but he happened to be shooting people that were hitting him over the head with skateboards, and one pulled a gun and all of that kind of stuff. But in Florida, the prosecutor can argue, yes, we have stand your ground, but Mr. Ericson could have retreated. He had the means to retreat, even if he was legally able to use his firearm to defend himself. Really, he should have left. Don't you think? And if you can convince a jury of that, you can go to prison. All right. Let's talk a little bit now, a little more in depth about Florida's castle doctrine and stand your ground. Those are two different things. It's a little bit irritating when the news talks about somebody standing their ground in their home. That's really not where that law applies. We'll also talk about defending others and defense of property. All right, castle doctrine is based on Old English law, which a lot of our laws are based on. And basically it says a person who is in a dwelling or residence in which the person has the right to be has no duty to retreat. That is in Florida statute. So, don't have to.
They don't call it castle doctrine in Florida, do they?
They should.
Yeah, but they have it, but it's not called that, I think.
No, it's called that. It just, sometimes in the news, you'll hear about it. For example, there was the woman who, there was teenagers on her property. This was over near the forest. I'm drawing a blank on where. But this was like 2 years ago. And she got in an argument with some teenage boys. They went home, got their mom. Their mom came pounding on the door of her house. She shot through the door, killed the woman.
That's Ocala.
That was in Ocala.
I thought it was further.
No, it was actually this side of Ocala.
Oh, okay. Well, regardless.
And she was shot through the door.
Can't do that.
Yeah, she shot through the door. I remember hearing the news talk about, they're claiming stand your ground. I'm like, no, it's not stand your ground. She could make an argument about castle doctrine, because in Florida, well, we'll get to that. Or do we get to that? I think we may or may not get to that piece. I don't remember, frankly. No, I think we will get it right here, maybe, perhaps. So this particular statute says that a person is presumed. So what does it mean to presume? In this language, it means by law, we're going to assume this is the case. A person is presumed to have held a reasonable fear of imminent death or great bodily harm if a person was in the process of unlawfully or forcefully entering, or had unlawfully and forcefully entered a dwelling, residence, or occupied vehicle, or if the person had removed or was attempting to remove another against their will. So in that case, woman, she could have tried to make an argument of, that woman was trying to break in. She was threatening me. They had a long history of conflict between the two of them. She was an older woman, younger woman. Yeah, there was race. Race comes, again, a factor to consider. Race comes into play. Whether you like it or not, race can come into play. You're going to make me chase a rabbit if I don't burn too much time. But do you remember this? Houston, Texas, black male comes into a taco restaurant-y kind of situation, is robbing people at gunpoint. As he's walking towards the door, but towards some other customers,
Shot.
he got shot in the back 4 times. He went down. It was a Hispanic male that shot him. Shot the gentleman a few more times while he was on the ground. The gun left the person's hand, but one could argue the shooter didn't know that because of all the chaos that's going on. Then he put 1 round in his head as the coup de grace to make sure that he was dead. Then he picks up the firearm and discovers what?
Plastic gun.
It was a BB gun.
Don't matter.
Doesn't matter.
It doesn't matter because you are under a reasonable expectation that that guy's waving around a real gun. So the fact that he's doing a toy does not matter. I think he took off. Right. What does that make a person look? Guilty or not guilty?
Guilty.
Looks guilty. So you're better off waiting for law enforcement. That's a whole other separate thing. But wait for law enforcement. This gentleman took off, found an attorney, eventually turned himself in. And do you remember what happened to him?
Let him go.
Let him go. Why? I'll tell you why. It was Houston, and it was Hispanic on black. I would be willing to bet if the shooter was white,
They'd be trying.
he probably would be tried. And frankly, would not surprise me if he got convicted. The first 4 shots, clearly justifiable. The next 3, a little bit more arguable.
You don't know what shot really killed him. It could have been the first 4.
How come you shot him so many times? Because I ran out of bullets.
Yeah.
There you go.
Don't ever say that.
Let the sheriff say it.
Sheriff, yeah, the sheriff in Polk County will say that for you. But please do not say that because it'll make you look
Make
guilty.
you go to jail.
Oh, there is,
I had to say the taxpayers.
touch on one other thing about this particular piece. Residence, dwelling, what are those things? Besides your house, what else might that include?
Your car.
Car? Your car has to be occupied. You can't shoot somebody who's trying to take your car, but if you're in an occupied vehicle, or if my grandchildren are in the vehicle and I was pumping gas, that's defense of others. I'm not defending my vehicle. That's the difference of property. I'm not defending my vehicle. I'm actually, even with castle doctrine, the argument is I'm not defending my home. I'm defending myself and those that are in my home. What else? Oh, where else might you find yourself in a dwelling out in the forest? If I'm in my camper or my tent.
Outhouse.
For you, maybe, I don't know if that's your dwelling or not, but any place you have a right to be would come into play. But this for castle doctrine has to do. It also would come into play if I'm staying at my daughter's house, for example, in Tennessee, then I would have a right to defend my family there as well. Ooh, thank you, Lord. Made it a little better to see.
Overcast.
All right, there was. We'll get to the exceptions in a second. Presumptions. This does not apply if you are in a dwelling, etc. The person has a right to be. Does not apply if the person has a right to be in or in it is a lawful resident of the dwelling. So, for example, if my daughter and son-in-law were having marital problems, and I'm babysitting my granddaughter, my daughter's at the attorney, husband was kicked out of the house, but he comes back and he wants in. Can he force his way into that home?
It's his house.
It's his house.
As long as
Can he take his daughter from me?
Oh, yes.
Oh yeah, it's his daughter.
As
So
long
I
as it
could not
doesn't
use deadly force to prevent that.
Yeah.
You can't enforce it.
Doesn't apply if, okay, the person, this covers that about children and grandchildren. If the person has guardianship of it, they can. Unless, one caveat, unless there's a restraining order. Because then he no longer has a right to that child. This presumption also doesn't apply if you're a criminal. If you're selling drugs out of your house and people break into your house, you can't shoot them and claim self-defense. Plus you got other problems now that law enforcement is involved. You also can't shoot law enforcement. Whether they have a warrant or not, you cannot use deadly force against law enforcement. Make that argument in court, not at your front door. All right, person, if, again, this is a different statute, but it reinforces, if a person forces their way into your home or into your car by law, the presumption is they mean you harm. Therefore, you've met one of those, the pillar of, I have a statute that says I have a right to be afraid for my life, I'm where I should be, I'm the innocent party, so on and so forth. I can use deadly force, whether they're armed or not.
Can't they say you could have drove off?
They could make that argument. They could, again, in Florida, you could make the case of, hey, still could have escaped. You chose not to. You chose to shoot instead of drive off.
When she's sitting in the passenger seat, she'd have a hard time driving off.
Yeah, right. I was just gonna say, that's the passenger side of the car.
And with
Well,
your-
she's
Unless you're in England.
No, she's a wife, she's gonna tell them.
yeah, she could, regardless. In this particular case, the guy's got a gun, so the spouse could drive off. The spouse could say, honey, get back, and put a round in him. All right, this is duty to retreat. So up until 2005, Florida had a duty to retreat. This reads, a person is justified in using deadly force or reasonable force would be necessary to prevent the imminent death or great bodily harm or a commission of a forcible felony, and we'll cover forcible felony in the next slide. This is the Trayvon Martin, George Zimmerman case.
Stand your ground?
I'm not going to, yeah, that one would be stand your ground. I'm not going to go into all the details, but what I do want to emphasize here is it took, I think, almost 2 years before Zimmerman went to trial. Less than that. In that time, he gained 145 pounds, I believe it was, from the stress of that event. It cost, want to take a guess at how much it cost him to defend himself? Yeah. And his life was over. I mean, he's innocent, he was justified. I share all that to say, anytime taking somebody's life is serious business, even if you're justified. So one, to avoid the consequences, you need to understand the laws. Two, if you can, don't be involved in those kind of situations. Situational awareness is helpful, get out of there, etc. But if you have to be able to use a firearm, be prepared, be efficient with your firearm, and that's just my reminder that my time is quickly elapsing. All right, forcible felonies. Forcible felonies include any kind of violence that are geared towards, I can't even read that. I know there's murder, manslaughter, arson, home invasion, carjacking, rape, sexual battery, robbery. What's the difference between robbery and theft?
It's stealing from, but robbery would be on the person.
So there is, yeah, theft is when they're taking your property from you and they want to take, and you're not going to get it back. Robbery is some sort of violence is used to take that property. Kidnapping, aggravated assault, aggravated battery, aggravated stalking. So those are all considered forcible felonies. And therefore, deadly force would be justified in defending yourself against that. All right, in this picture, again, we run across this same kind of scenario. Somebody appears to be trying to steal her purse. Would she be able to use deadly force?
No.
Generally, the answer is no. She would have to be able to articulate, he really didn't want my purse, he wanted me, my purse was just between me and him. I mean, she would have to be able to articulate something like that to be able to justify using deadly force in that case. Here is a gentleman who's breaking into your vehicle. Can you use deadly force against someone who's breaking into their vehicle?
Only if you're in the vehicle.
You're not in Texas.
Unless there's
No.
somebody
Am I
in
in-
there.
No.
Am I in the vehicle?
You're not in the vehicle, you're at home. So I hear something out by my car, and I'm concerned.
Is it a Tesla?
Because you have a
That one is not. So when I go out, might I go out and try to discover what's going on?
Of course.
If I'm going to do that at night, might I go armed?
Yeah.
If I find this gentleman breaking into my car, what am I going to do?
Citizens arrest.
Encourage him not to do that.
I would, yes, discourage him not to do that. Citizens arrest. So I'm just going to say, hey, you're under arrest. And what might he do?
No, how about it, can you pull your weapon and point it at him and say, you're under arrest, I'm holding you for the police?
And he may take off.
But then I can shoot him, right?
No.
So citizens arrest is an interesting topic that I won't chase. You need to dig deeper into whether you'd be justified. You can do a citizen's arrest for somebody who you see committing a crime. The question would be, what force can I use in order to make that happen? So anytime I brandish my weapon, am I committing a crime?
Yes.
Yes.
Possibly.
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 So keep that in mind. Here's what a situation that I did see in Texas. I'm sorry, didn't see, but I saw it on the news. A gentleman, same kind of scenario, four or five individuals came out to break into his truck. He came out to check what was going on. He was armed, so were they. Firefight ensues. 40-something rounds are expended.
Nobody gets shot.
Nobody got shot. They drove off, cops show up, and the gentleman says, this is what happened. They came, they broke into my truck, they started shooting at me first. I started shooting at them. I was so afraid though, I couldn't see my sights. I was just sending rounds their direction. You know what the cops did? They arrested him.
Firearm in city limits.
Yeah, well, and jeopardizing, so there was rounds that went into houses and cars. Fortunately, nobody was hurt, but that can get you in trouble. So here's the last thing I'm going to say about any of that is, do not talk to law enforcement until you've talked to your attorney. Simply give a description of what happened. These guys did this. They shot at me, I returned fire. I'll be happy to fill out a complete report after I speak to my attorney. I'm going to now exercise my 5th and 6th Amendment rights. That's the right to remain silent and to have counsel. Until that time, end of story. Then I can say stupid stuff to my attorney, and my attorney can put it in such a way that they can give the law enforcement what they need. All right, any questions, comments, concerns about anything?
You know, on that car thing, when you saw somebody outside fooling with your car, you can use force, but not deadly force.
Yes. So what's the difference between force and deadly force?
And
Bat.
That would be deadly force. Give me an example of force that's not deadly.
Hit it with your flashlight, pepper
No,
spray.
pepper spray.
Pepper spray's good. You're simply using my voice as a matter of force. Hey, what are you doing? Get away from my car! Maybe he leaves. Maybe I go out and pepper spray him. Maybe I put a bright flashlight in his eyes. I can't use my knife, I can't use my club, I can't use my gun. Can I use my dog?
You could punch him.
Oops, the dog got out.
You frightened my dog.
Yeah. That's a whole nother conversation.
My God, PTSD.
I went to school with a guy, a friend of mine from college. He had an Impala, and it, had hydraulics and everything. And he pulled in a gas station to get gas, and windows were all rolled down and everything, and he went inside the gas station to pay, and a guy jumped in it to take off, and he came out and jumped in the passenger window to fight the guy off, and the guy went pop, and shot him right in the forehead, killed him
Yep.
over a car.
I say, is there any property worth your life?
No.
I will die for my kids and grandkids, etc., but
And is there any property worth the bad guy's life?
some people might think otherwise, but,
Bad choices.
yeah, because, again, the fecal storm that comes your way in something like this is horrendous. Again, you're going to spend hundreds of thousands of dollars defending yourself. You are going to spend, likely you will be arrested. Likely you will spend some time in jail until your attorney can get you out. If you don't have an attorney on retainer, who do I call? I'm going to call my kids, and then I need to get an attorney. Then the retainer fee, the attorney is going to start at
$50K?
$50K. That's just to get started.
That sounds like an advertisement for USCCA.
That's such a softball. I will simply say there are a number of good organizations out there that help with those kind of things. If you carry a firearm regularly, you should have insurance. USCCA is, that's who I'm with. I was with another organization before that. I think USCCA is better. CCW Safe is another one I would highly recommend. They got good people. And you will spend less paying for that insurance than you do on your car. Certainly not in your house. So what's more valuable? My car, my house, or me spending $1 million defending my life and possibly spending the rest of my life in prison? Also, Andrew Branca is an attorney who does nothing but this, and he says 10% of juries get it wrong regardless. So, and then I promise this is the last thing, and if you win the legal battle, the criminal legal battle, what might come next?
Civil suit.
Civil suit.
You got a civil suit, but you just spent all your money because you mortgaged the house and all of that.
He was such a good boy.
What's that?
He was such a good boy.
Yeah.
It was.
Yeah, every criminal was such
I
a
have
good
one
boy.
question.
Well, a question.
With what's going on now today with them keying the Teslas and everything else,
Hang on.
where they're keying the Teslas, there was a guy on Nextdoor who was talking about he had his Make America Great hat and he went to a store. And then all of a sudden he heard two guys were talking about it and then they were going to rip his hat off his head. If somebody rips your hat off your head, is that considered an assault?
Sure.
Okay. Now, you're carrying your pistol, the guy
What is
just
the difference
assaulted you.
between
Now,
assault
I'm not
and
talking
battery?
about shooting him, but can you do a citizen's arrest? I'm holding you for the cops, you just assaulted me. And you got your gun pointed at me.
So, I'm not an attorney, and I'm not very educated in citizen's arrest. It is on my to-do list for Florida to see whether you can do that or not. My question would be, is it worth it?
Right. The hat. Yeah.
Over most anything. So law enforcement, even when law enforcement do arrests, I just have so much admiration for law enforcement. That's a rough job. You do not know what you're walking up on. You think you just don't know. You say, hey, I'm going to do a citizen's arrest. He said, oh, are you, old man? Yeah? And then he pulls out a knife and sticks you. And you're like, oh, I wasn't looking for that. I had a gun. I thought that was going to keep me safe.
Just a question.
Yeah, I would, you are, the best way to avoid this, or I should say, the most assured way not to get arrested or injured is to walk away.
You will be there.
Yeah, well, or not be there. And if you're someplace, if you're someplace where you think you might need your gun,
Don't go there.
yeah, you shouldn't be there. I carry mine everywhere I go. I don't expect that I'll need it here, but I still carry it. And if it's someplace where I'm concerned, then I ain't going there. It's just not worth it. All right, thank you so much.